Hi, I'm Danny Karen, your lovable lawyer here with your quick shot of legal wellness. Did you hear what Amazon did? I'm going to tell you all about it because it is really important. Why? Because it absolutely affects you. Here's what happened at Amazon. It got rid of its forced arbitration clause in the contracts it has with you as consumers. Now, what's forced arbitration? What the heck does that mean? Baked into every arrangement, every contract, every deal you have with Amazon to buy whatever product, whatever service, Amazon Echo, anything, is what's called forced arbitration. And that means if you have a beef with Amazon, a gripe, a grievance, they didn't give you what you ordered, they didn't give you as much as you ordered, something you ordered was broken, you can't take them to court. Instead, you have to submit your claim, your grievance, to private arbitration, a private tribunal, where Amazon hires the arbitrator, pays for the arbitrator. It's a private, secret arrangement. And the arbitrator almost invariably will rule for the person who hired them, in this case, Amazon. I'm not just making that up. The data show that almost all the time, the arbitrators are going to find for the corporations who hired them and paid for them. And it stands to reason because if they don't, they're not going to get hired again. So if you have a problem, you go to private arbitration. You can't sue them. You forfeit your Seventh Amendment right to a jury trial, which is a pretty darn important thing. I mean, it's in the Bill of Rights, the Seventh Amendment. That's in the top 10. I mean, that's a big one. And you can't do it. Why? Because Amazon says you can't, and the U.S. Supreme Court said, you know, something like that in the contract, that's legit. That's binding, and you can't go to court. So what's the effect of that? Well, I just told you. You're going to lose most of the time. So they took it out. Why would they take it out if they're going to win most of the time? Well, because a bunch of consumers, represented by a bunch of lawyers, finally gave Amazon what they asked for. They gave them so many darn arbitrations that Amazon couldn't even keep up with it. They gave them 75,000 arbitrations. And remember what I said, Amazon in its contract that binds you to arbitration where they think they're going to win most of the time, they've got to pay for it. That's what the contract says. So if arbitrations go off at like $2,000 a pop because they're private and it's a for-profit business, is arbitration business, it's 75,000 arbitrations times $2,000 each, just to start, by the way, because different add-on costs, go on as you go through your arbitration. That's going to be right off the bat. Calculator won't even do it, but it's $150 million in arbitration costs just to get started. And it was crippling, and Amazon couldn't take it anymore because consumers gave Amazon what they wanted. So Amazon said, you know what, to heck with this, we're going to pull it. We'd be happier facing folks in court. Win or lose, we'd be happier facing folks in court. Now, you might be wondering, what claim was so important to 75,000 people that they decided to file arbitration requests? Well, actually, the case involved Amazon Echo. It was a privacy case because all states have privacy statutes. And the statutes say what you can and can't do when it comes to recording people's voices. And think about what happens with one of these when you make requests. Like, for instance, Alexa, play the Beatles.
Shuffling songs by the Beatles on Amazon Music.
And there you go. And what Amazon Echo just did, Alexa, stop. What it did was to, in some manner of speaking, record my voice. Whether the device or Amazon kept it or not, that's a merits question. I don't really know what happened. But the claim was that practice, that principle, what just happened there, violated privacy laws in several states. That's why so many people got worked up about it across the country and filed arbitration requests as required under the contract, and Amazon had to pay $150 million right out of the gate. And even if they win these claims on the merits, they lose for winning because they're out of pocket $150 million and up and up and up as these arbitrations go forward. So again, the consumers and their lawyers gave Amazon precisely what they wanted, which prompted one lawyer in Chicago who was working for Amazon to say, I don't think it's really fair what's happening to Amazon. And it's like, seriously? How can that not be fair? I mean, Amazon wanted it, so you better be careful what you wish for, because they got it big time. Now, I worked on one of these mass arbitrations once involving a restaurant, and it is a ton of work because unlike a class action where there's one person who sues as a representative for everybody else? This is, mine was 5,000 workers, and that was a ton of work because every single arbitration was its own file. You had to work them all up to send that message, to get that point across to the defendant that, you know what, we're going to do justice for all these folks individually. Why? Because your employment agreement with them required arbitration. So not just consumer agreements require arbitration, like your contracts with Verizon, with Uber, with Visa. But if you're a worker, a lot of your employment materials require arbitration too. And that's what happened in my case. And we ended up resolving it, but it was not without a ton of work. Now, they didn't capitulate. Amazon just said, forget it, I'm fed up, we're fed up, enough's enough. Now, the same type of practice was happening with DoorDash a little while earlier, before the Amazon case. And DoorDash, who was requiring its workers to go to arbitration too for a workplace grievance, they said, you know what? This is too much for us to handle. We've got to pay for all these arbitrations. We don't want to do it, even though we required it in the employee materials. We're going to ask the court to let us go back into court where we said we didn't want to be in the first place. So they didn't pull the arbitration clause. They just said, let's go to court. And it prompted the judge there in San Francisco to say this. This is good stuff. Listen to this. The judge said, no doubt DoorDash never expected that so many would actually seek arbitration. Yeah, no kidding. Instead, in irony upon irony, DoorDash now wishes to resort to a class-wide lawsuit, the very device it denied to the workers to avoid its duty to arbitrate. This hypocrisy will not be blessed. So didn't go so well for DoorDash because, again, you got to be careful what you wish for. Now, what does this mean going forward? Well, what it means right now is that you don't have to worry about arbitrating your claims against Amazon anymore because that clause is gone. They did it very quietly. They didn't want the publicity that I'm hoping we're generating here, but that clause is out. Will it mean other companies will pull their arbitration clauses? Will Uber pull its clause? Will DoorDash pull its clause? Will Visa, will Spectrum, will Time Warner, will T-Mobile? I don't know. Nobody can know. But what today means is that, and what this video means, is that you can be more empowered. You know what to look for. You know it's in your contracts. You know it's not in your Amazon contract anymore. And you've got more legal aptitude and more legal wellness to know how to conduct your affairs as you're moving through commerce, as you're moving through life. So I hope this helped. I hope it was informative. It's topical. It's hot. It does affect everybody. And I'll keep putting these videos out, and keep teaching you as best I can how to stay careful and how to be careful, how to stay safe, and how to raise your legal wellness. So take care, everybody, and watch my videos online and be sure to subscribe. Thank you.